Greetings, and thank you for joining today's discussion, Estate Planning Essentials. My name is Kristen Kolish. I am one of the retirement plan advisors with the Mahoney Group of Raymond James. And today's discussion, I can't imagine, was the meeting that you were most looking forward to this week. I can appreciate that talking about estate planning, while very important, can bring up all sorts of mixed emotions. Just some housekeeping items before we dive in. I'm going to be sharing some slides. Once we get into the meat, I'm going to take myself off video so you can focus on the information that's being presented. But rest assured that I would be happy to share these slides after the program. So don't feel like you need to take copious notes. You can listen and take it all in, knowing that this presentation, along with a couple of other supplementary documents, will be provided as a resource to you. Another thought that I wanted to share heading into this conversation, the title of the presentation is Estate Planning Essentials. I want you to focus on the middle word, on planning. So this is one part of an individual and a family's overall financial plan. So if I were to be presenting, let's say, on retirement planning essentials or financial planning essentials, the first two steps in that process is actually the same as it would be for this discussion. And that is first and foremost considering, what do you want to have happen? Now I'm going to build out this discussion as I go through my prepared remarks over the next, 30 to 40 minutes. But what are you, your spouse, your family's goals when it comes to your financial plan? Because you're going to have given that some consideration to make decisions related to your estate plan. The second step in any planning process, whether it be estate, retirement, financial, is to take inventory of where you are. For you to have an understanding of what are your assets, what are your liabilities, what are your cash flow needs and cash flow sources. So those are all important factors that relate to any part of this planning process. As a follow-up to the program, one of those supplemental documents I just mentioned is something that we call an essential document questionnaire. So it's meant to help you organize, both for your own benefit, but also in the context of this conversation, your heirs' benefit, all important pieces of information. Because just like with any planning process, we want to be making decisions and considering all the different trade-offs when we're dealing from strength. I see too often where something happens and clients or investors are left to make decisions, not only when it's important for them to do it financially, but also emotionally. They're not in a good spot to do that because of grief or other reasons. So with that, I do want to get started, and let's just acknowledge the elephant in the room. The idea of estate planning for many of you means that I'm planning for when I'm no longer here, for after my demise. And yes, that's part of estate planning. But what you want your assets to do after you or your spouse or your family's passed could inform what you're doing today. So this is very much a dialogue that is fluid. I do want to acknowledge that every individual is different, just from a financial planning perspective, estate planning as well. And you may have varying degrees of comfort and, quite frankly, needs when it comes to estate planning. So that does beg a very important question, which is, do you need an estate plan? Well, in a study done by Caring.com just this year, 40% of Americans didn't think they have enough assets to create a will. So I'm going to talk about all the reasons why it's not necessarily about the size of your assets, though that could inform the complexity of your estate plan, but everyone needs some type of estate plan. If you're over the age of 18 even, and that might be a surprise, but I'm going to share an interesting point momentarily that I think that I'm hopeful that you'll take away and share with your family and friends. anyone over the age of 18 needs some form of estate plan. You may not think of it as such, but if you consider healthcare needs under the umbrella of estate planning, I think our eyes are going to be more wide open. Now, I am not an attorney, I'm not a lawyer. I am a financial planner. So myself, my team is not going to be a replacement for you engaging with legal counsel or legal resources, which, depending on the complexity of your estate, may warrant you going out and hiring an individual attorney or a lawyer. But I do want to share an interesting conversation I had just this week, quite frankly, with one of our retirement plan participants who was pleasantly surprised as part of their open enrollment process that they had access to legal resources. There's also some record keepers, some 401k providers who offer some legal resources as a supplemental benefit to the retirement plan. So it doesn't have to be an expensive process. I am going to walk you through steps for considering where are you in the estate planning process from a needs standpoint and from the standpoint of what you've done to date. So let's consider a few things. I'm going to talk about, what is probate? So I'm also going to walk you through estate planning documentation. What is a will? What is a beneficiary? Beneficiaries, through the context of the way that you're interacting with the Mahoney Group, a beneficiary on a 401k, 403b pension plan is extremely important. And a little known fact, did you know that assets held in accounts that have beneficiary designations actually pass based on what that designation says, regardless of what your will says? So I've seen scenarios where early in someone's career, maybe pre-spouse, pre-kids, they name a brother or a sister as a beneficiary and never revisit that. God forbid something happens later in life, even if your will says that your spouse and your 3 children should be getting your assets, that 401k balance that says your brother should get it is what the legal world is going to interpret as the execution of your estate. So we're going to talk about what are triggers to revisit estate plan. Life events. You get married, you get divorced, someone passes away. Those are all reasons to revisit estate planning. And one of the things that should be relatively easy to update are those beneficiaries. I mentioned before how important it is to know where your documents are. And in addition to the essential document checklist that I will share as a follow-up, I am also going to share an executor checklist. So what are the roles and responsibilities of your executor? Or if you happen to be named as an executor, it is a handy checklist as well. Again, through the context of we don't want any of the to-dos, we want you to give some thought to before you're put in a position where grief and emotional needs impact your judgment. We'll talk a little bit about trust. And this is an interesting point that really straddles both estate and retirement planning, is that there has been legislative changes that is impacting some decisions that you may be making as it relates to retirement accounts and income planning. The Secure Act, well, I'm going to share a slide on that in a moment if you've heard about that in the press. The fact that required minimum distribution age is getting pushed back. Well, that legislation is also impacting how you distribute assets, both during your lifetime and beyond. So I'll get into those details, but it's just great examples of how this estate plan is really part of your overall financial plan. And with any planning process, we want to think about, well, what do you want to have happen? What are your goals, as I mentioned earlier? So give some thought to, for your personal circumstances, ultimately, who do you want to inherit your estate? What does your family construct look like? Is it immediate family members? Are there extended family or friends that you want to include into the mix? I often see now, I mean, you may think that, well, this is pretty simple. It can get very complex, particularly as you're living longer, different life circumstances. I see many cases where there's mixed marriages. So think about this. Perhaps you are a widower or you are divorced and you get remarried. Well, you might have had children with your first spouse, but you married someone who also has children. What do you want to have happen with your assets? Communication is going to be very important. But self-reflection is also an important piece of this to get a clearer vision of what this could look like. And I'm just going to throw it out there and acknowledge that for some circumstances, this is not obvious. It can be tricky. And it's something that could be fluid, that could change over time. So that's an important thing. There's good and bad with that. So if you set up your estate plan, don't think of it, check the box, I'm done. It's something that you do need to revisit. With that said, if you set an estate plan and you're like, oh, I wish I did something differently, well, of course, that's something you can readdress. And we'll talk about that. A lot of things you can readdress. Not everything, but a lot. Are you charitably inclined? I've seen clients perhaps use assets during their lifetime to benefit charities, but you could also name a charity as a beneficiary of your estate. And I can't think of too many people, but there is a fourth option for inheriting your assets, and that's the US government. So with most estate plans that I see, clients are looking to minimize beneficiary number 4 and trying to avoid having to pay estate taxes. Now, the estate tax limit in terms of the amount of assets you have has gotten higher and higher, and there's some legislative activity that is going to be very important. You're going to see it in the news in the coming months, and you may have already, because one of the tax Act of 2017 that was passed by President Trump is set to expire in 2026, which would revert us back to the limits back then. Again, we'll get to that. If your estate is less than a few $1 million, then estate taxes is not your immediate concern. But oftentimes people don't realize when you're adding in your estate, it's not just what you have in your 401k or in a brokerage account, it's also inclusive of the assets of retirement assets, of course, but also real estate assets. So taking a step back, what is estate planning? What are we looking to accomplish here? Well, one, you want to protect and enhance your net worth during and after your lifetimes. So an important consideration when you think about, well, who do you want to inherit your assets? Is this something you want them to receive upon your death? Or is this something, assets that you'd like your family or friends to enjoy while you're still living? And I'd introduce that theme of a living legacy. I'll give you an example of that. What if you have adult children who perhaps have their own children and you want to help them either buy a home or help with some education costs? You could wait and have the assets passed to them in the future. But if there's an immediate need, why not share during your lifetime, if that's one of your goals? Now, some of you on this call I know are already thinking, listen, that's a luxury problem, and I appreciate that. Perhaps your number one goal, and maybe you're not even sure you're going to meet it, is just simply having enough money to live during your lifetime, and that is very valid, and you still need an estate plan. However, if you think that there's going to be assets left behind, if you've saving over the years, a relatively modest lifestyle, you do want to think about when and how your heirs receive those assets. The transferring property, what does that look like? I mentioned before the taxes. Avoiding probate. I want to take a minute here and just go off on a bit of a tangent to define what probate is. And I can appreciate everyone on this call has varying comfort level with this topic. So if this is a little elementary, please forgive me for the moment. Just view it as a refresher. Probate is the legal process through which your estate is settled. Now, the probate process is a public one. So depending on the state in which you live, probate can be pretty onerous. I am a New York State resident. Probate in New York is expensive and time-consuming and also public. So not all of your assets are subject to probate. So out of the gate, without you having to do anything, assets that sit in retirement plans that have a beneficiary are not subject to probate. Life insurance policies that have a beneficiary are not subject to probate. Accounts that you are held joint with rights of survivorship are also not considered probatable assets. Assets held in trust are excluded from probate. However, if you have a savings account, a checking account, a brokerage account that you hold individually or in a different joint manner, joint tenants in common, then those assets, when you pass, will be subject to probate. So that for some people, this is a goal to seemingly avoid probate. I will tell you, New York is bordered by New Jersey. New Jersey, the probate process, you may still want to avoid it, but it's not as expensive. Okay. Not that we're looking, hopefully this doesn't happen, but again, estate planning is risk mitigation. It's risk management. It's planning for a time where you may not be in the mental state to make decisions yourself. And that includes the planning for incapacity. And that's going to inform some health documentation that we'll get to. And last but not least, appointing legal guardians. Now, this can be a very tricky one. And I know I've had that conversation myself with my spouse, and we're deciding for my 3 kids who are under the age of 18, who do I feel comfortable with that if God forbid something happened to him and I, that would take care of them. So I can appreciate that there may be a very obvious choice. There may not be a very obvious choice, but it's a very important decision to make. So I would simply stated, if you have children, you should have a will that outlines who your guardians for your children are. And as they get older, then your estate planning needs change in that regard. Now, the tactics to achieve this, first you need to know what your goals, and then you're going to work through the legal documentation. So this sheet here is going to be a little repetitive, this slide, I should say. But if you were to, after this conversation, have a follow-up conversation, let's say with your spouse, this is a great starting point. Some questions for discussion. We went through, who do you want to inherit your assets? And if you want your children to inherit it, how? Is there an asterisk next to that? Maybe you want them to inherit it equally, or maybe for a whole variety of reasons, there may be a different strategy. Do you want to have them have the ability to inherit their assets, your assets outright? Or do you want to have some control after you're gone? And that would be a reason to have a trust, to put some guardrails around the assets that they may inherit. Timing, I mentioned this before, the idea of a living legacy. Do you want to leave your assets during your lifetime, at death, or a combination of the two? I mean, we have clients who share that, you know what, I'm gonna splurge and spend money on a family trip that may be outside my budget, but I'm going to plan for it occasionally because that's a living legacy. It's an experience. We're all going to spend time together. We can't do that when I'm gone. And I gave the example before of education. This is a tougher one. Who do you trust to handle your affairs in the event that you can't make decisions for yourself? Whether that relates to medical, financial matters, guardianship, choosing who the executor of your estate is. In some regards, that conversation is, I'm sorry I named you executor, not congratulations I named you executor, but it's someone that you trust. and that could do a good job, knowing that there's going to be professional resources, likely your estate planning attorney, who will help with that, and also your financial advisor, who will help with the actions that are needed after you have passed. And do you expect to have a taxable estate? So I think if you're not sure, by the time we finish the program today, you'll have a better sense of that. So there are lots of times where I see estate plans that should have been updated. So here are some triggers. I mentioned before, life events. So changes to your family, marriage, divorce, deaths, births. Those are all reasons to revisit your estate plan. Changes to your financial position. As you continue working, hopefully you're saving. If your wealth situation is a lot different than it was when you originally set up your estate plan, there may be additional strategies that you're going to want to employ. Certainly in the case of any type of liquidity event or any big payment, perhaps, and we see this more and more when we've got the sandwich generation that is taking care of elderly parents and then also children, or even having adult children. It's more and more common for those around retirement age, pre-retirement age. You could also be the recipient of an inheritance from parents, aunts, uncles, friends, what have you. So any type of inheritance you receive could inform decisions on your estate plan and your financial plan. And then, of course, from a legislative standpoint. So I know that, with just less than 2 weeks away from an election, during which time, taxes and legislation has been a hot topic, this can be a polarizing conversation. At the end of the day, it's a conversation that you and I have, we don't have so much control over what's going to happen with taxes. We can plan for it. And I think over the next 6 months or so, we're going to be able to see, are there changes that we're going to have to make to our estate plan? This is for a very specific subset. And just because you're probably, I'm sure your ears perked up when we talk about anything that touches on politics, I am going to just skip ahead to one slide for a minute to ease your concerns, because you may be reading the newspaper, listening to news coverage and thinking, oh, what does this impact me? So let me take a step back, and what the issue at hand is that in 2017, the Tax Cuts and Jobs Act increased the federal lifetime tax exemption amount to $13.6 million per person. Okay, so what that means is that if you have assets of less than 13.6 million, then you are not subject to a federal estate tax. Okay, so that's most of the population. So this is an issue that you might read about, but you may not be impacted by. If the estate tax provision is allowed to expire in 2026, that 13.6 million is going to revert back to what it was in 2017 on an inflation adjusted basis. So in 2017, it was 5 million. Analysts are estimating, economists I should say, that it would revert back to about 6.6 million. So if you have a net worth of less than 6.6 million, or a married couple times that by 2, then federal estate taxes are likely not your primary concern. Now, depending on where you live, state estate taxes could be impacted, but we'll get to that as well. I just wanted to bring that up because I know there could be a lot of anxiety around, changing in taxes. Is this going to impact me with, upcoming election and the like? For the majority of people, the estate planning tax piece is not going to impact their financial position. So that's driven on what the size of your estate is. So I mentioned before the slide here that has these questions. This is a great resource to have a conversation with a spouse or an important family member. This is a checklist that I have here. I'm going to include at the end of the program. 8 important estate planning steps. Now, 1 and 2, update beneficiary designations, create a will, and I'd say the third, establish healthcare directives. Those are 3 things that almost everyone should be doing. So let's just throw that out there. And I'm going to get to healthcare directives in a minute. Do you need power of attorney? We'll talk to that. A trust. Why do people use trust? They use it for a variety of reasons. Sometimes it's to avoid taxes, though usually it's just impacting the timing of the taxes. But most often, a trust is used to protect assets and allow the grantor in some way, shape, or form to control those assets. So think about your personal financial situation. Is that something that may be necessary? Now, a trust, and we'll see a slide on this, a revocable trust could be a way to avoid probate. So again, probate's that legal process that is public that settles an estate. Planning for the distribution of retirement assets. The Secure Act legislation may inform how you ultimately spend down your assets in retirement. And just as an aside, this school of thought had traditionally been, well, let your retirement assets grow as long as they can because they're tax advantaged. Meaning that when you retire, spend down your taxable accounts before taking distributions from your retirement accounts. And I'm just going to, a little spoiler alert, asterisk, there may be reasons to question that rule of thumb because of changes that have been made in the last 10 years on the distributions post-death there. Are you in a position for gifting? Does that fit into your estate tax? And then lastly here, are you in a position where estate taxes is a risk? If so, how do you go about decreasing or eliminating that risk? So the next piece is really level setting definitions. And I appreciate some of this will be a recap, some of this will be new for you. So healthcare documentation is often overlooked, but so very important. And you may be surprised that healthcare documents is not something that you pursue through the medical profession. These are legal documents. So this is going to be your estate planning attorney that would help you with this. A living will outlines what happens in the instance in which you are incapacitated. And it applies only to end of life conditions. So you'd be giving thought to your position on life support, for instance. And let me just acknowledge, these are hard things to think about. And they may be even harder things to talk to your family members and important people about. But it's important to have a living will. A healthcare power of attorney nominates an agent to make decisions if you're incapacitated. This does not have to do with end of life decisions. And you may consider naming an agent or an alternative agent. In most states, you cannot name your doctor as your healthcare POA. It's someone separate from that. The HIPAA authorization and the HIPAA authorization along with a healthcare power of attorney is often referred to as a healthcare proxy. Now, I'm sure many of you are aware, HIPAA informs privacy. That's what the P stands for here. And if you do not have someone authorized to be given medical information, then you could be in a position where your loved ones are not getting updates during a crisis situation. And I'm going to give you an example here. Think about your children. Well, when you're the guardian, HIPAA is not relevant. You as the guardian, you have access to that information. At the age of 18, you are no longer a guardian. Any person over the age of 18, in my opinion, should have a healthcare proxy. I've had friends, I've had family members, been in situations where something happened to an adult child where they could not get access to the information they needed, or the communication with a doctor or other medical staff was delayed because they did not have a healthcare proxy. So this is my public service announcement, particularly if you have adult children or grandchildren going off to school, to college. This is an important planning takeaway, is to make sure that there's some type of healthcare proxy that you can stay informed if, God forbid, something does in fact happen. So now we're going to transition away from healthcare and talk about financial documents. A power of attorney authorizes someone else to make decisions on your behalf. So you could have, for instance, if you've got a brokerage account, I know Raymond James has their own power of attorney documentation. You can use your financial institution's documents, or you can have your attorney draft a document for a POA on finances. This is important not only in the event of incapacity. I'll give you a very common example. Sometimes there's a married couple where one spouse is more involved in the finances than the other. And let's say at a financial institution, you have a joint taxable account and you each have IRA accounts. Well, the spouse who controls the finances without a POA is not authorized to make decisions on investments, for instance, of his spouse's IRA account. So there could be instances, just even for facilitating the management of your assets, where having a power of attorney is an important piece of this puzzle here. The last will and testament is the document that's drafted by the attorney, and that outlines how your assets are distributed at death. All of the assets, with the exception of items that pass by beneficiary designation. Now, as part of the will, you can name a guardian for children. Sometimes you would include instructions around burial or cremation, that could be a separate memo. If you have thoughts, for instance, on who should be inheriting a special piece of jewelry or artwork, all of that is stuff to consider here, which I can appreciate can be a lot, can be a bit overwhelming. The last piece of documentation that I'm going to go into here, and I would really couch this as like Estate Planning Essentials 101. If you want the intermediate estate planning course, that we'd be getting into more details around different types of trusts. So let me just reaffirm that if you are married, there's an unlimited amount of assets that can pass between spouses. So that's not necessarily a taxable event. The most common trust that I see being used is a revocable living trust. So a revocable living trust is meant to, one, avoid probate, and then also allow the grantor to control the assets. And I'd contrast that with another trust type that would be called the opposite, an irrevocable living trust. So that adjective is very informative. If it's irrevocable, it means once you put it in that trust, you can't take it back. With revocable, you put it in the trust, you can change your mind. You can certainly take it back. So because you still have control, the assets, the taxes, all flows through the grantor's social security number. Now, there is an estate planning strategy that would include something called a pour-over will. That says that at your passing, any assets that are subject to probate would pour over into a revocable living trust that at the death of the grantor becomes irrevocable. So just throwing that out there as one potential strategy. Another trust that I commonly see used is an irrevocable life insurance trust. So if you own a life insurance policy, if you own it personally, then the life insurance proceeds becomes part of your estate. However, If you have an irrevocable trust that owns the proceeds, then that's outside of your estate. Now, there are some nuances there. Paying the premium, for instance, shouldn't be coming directly from you. It would be coming through someone that perhaps you gift the premium to. There's something called a crummy letter. And if you haven't heard this and you're not interested in a life insurance trust, just ignore me for 30 seconds. But it's important to fund premium payments with a gift versus something you pay for outright to qualify to be excluded from your estate through the trust. So what is often common is that, let's say you've got an individual who gifts the premium payment, let's say to their children, who then buys the life insurance policy and covers the premiums. The crummy letter makes it so that the child doesn't actually need to pay it. The beneficiary, the life who's getting insured would pay it, and that child would sign a letter saying that, yes, you can use these assets that otherwise would have been gifted to me to pay the premium. So that's important documentation to ensure that assets or life insurance proceeds that are held in an irrevocable life insurance trust are in fact clear of estate tax and pass outside of your estate. Happy to answer questions about that. And I will say that at the end of this program, I'm going to share my contact information along with my colleagues. I can appreciate that some questions you may not feel comfortable asking in a group and/or may be very customizable, very individualized, I should say. So the benefits of this type of trust is to mitigate the time and cost of probate. And if there's any uncertainties around guardianship, that also is important. It allows that grantor to set some parameters to have some control over the assets. It could provide some tax planning opportunities and keep your assets and your estate plan private. And of course, a big benefit is that it is flexible and it can be changed. Now, the last piece of documentation before I get into retirement planning nuances related to your estate plan is something called an ethical will. Now, an ethical will is not a legal document. So up until this point, I have been talking legalese, legal documents. An ethical will, another name for it, I've heard it being referred to as a love letter to your heirs. And for some people, this is going to resonate. For other people, this is not. So, there's no offense either way. The objective of this document is to act as a written piece of communication to your family members, to instill, you pass your financial assets through a will, but how about personal values, priorities, family stories, and history? So I have worked with clients where they have documented lessons from the past, lessons from the present, maybe wishes for their heirs for the future. Touching on questions listed here that admittedly require some reflection, right? This is not a process that you would start and finish very quickly without giving it some prior thought. So just throwing this out there, sometimes this is a nice supplement to a legal document because it's a communication, it's a remembrance of your priorities, of your values, and your wishes for your family after you're gone. That can come in many different shapes and forms, but the idea, of course, is just keeping those lines of communication and memorializing some ideas that you might have shared, and I'm sure you have, verbally, if not verbally, your actions of what you believe in and what you think is important, but it's an opportunity to kind of tie that up in a nice bow. So I teased this a little bit with the federal estate discussion and the documentation, but there are rules and requirements around the size of your estate and whether or not there's going to be taxation. So first step is to determine, well, what is included in your estate, and all of the things here are included. Your cash, your securities, your retirement assets, your real estate. If you haven't done proper planning, insurance could be included in your estate, any annuities. If you're a business owner, certainly the value of your business will be. So depending on the nature of your financial position, you may or may not have the liquidity for your heirs to cover any potential estate taxes in the future. So that's an interesting nuance. If you're real estate heavy or if you're a business owner, you may be considering using insurance as a means of liquidity to cover those taxes if the assets that you own are not in and of themselves taxable. Liquid, I should say. I did get a question through the Q&A that I do want to just address here because I think it's timely. Can I make my own will using generic forms? You do not have to pay an attorney. It does need, like, you can write your wishes. It would need to get witnessed and notarized for it to be approved. But before you go down that route, I would encourage you to consider and ask, either through your retirement plan or through your benefits, either your benefits or your spouse's benefits, if there's any legal resources that you may have access to that you may not fully appreciate. So I mentioned before the estate tax provisions, exclusions from the estate and gift tax provision. So let me clarify. The amount that you can leave at your passing includes the amount that you're allowed to gift away during your lifetime. So that is one and the same. However, in addition to this lifetime exemption, you are able to gift each year, and this has been indexed for inflation, $18,000 in 2024 per person. So if you're married, that's $36,000. And you can gift it. It's not just family members. You can gift it to anyone. So if you're in a situation where the size of your estate could put you in the position where you're going to have to pay estate taxes, and again, admitting this is certainly not the majority of people, annual gifting could be an interesting way to reduce that amount. 529 plans are a very efficient estate planning vehicle in addition to education savings, because you do have the ability to pre-fund a 529 and use 5 years worth of gift exemptions up front. So an individual could put $90,000 in a 529 and not trigger their estate tax exemption amount. As a married couple, $180,000. It's also important to note that any payments made directly to a school or a medical institution is not considered a gift. So I've seen scenarios where families where they have the liquidity and the cash flow to do so, perhaps a grandparent's paying for tuition directly to the institution. Well, that would not be included in that $18,000 annual gift. Again, a little bit in the weeds, for a lot of people, not going to be relevant. So far, I've spoken about federal taxes, federal estate tax. There is a such thing as state, of course. So we know that state income tax, state sales tax, well, they also have state, they might have state estate tax and inheritance tax. This is a super handy map. So depending on where you live, whether there is an estate tax, and the estate tax would be borne by the estate itself, an inheritance tax would be paid by the person or entity that is inheriting the assets. So I'm not going to spend too much time going through this. You will have this as a follow-up, but depending on where you live, this will inform if there will be an additional tax bill by your estate or by your heirs. So let's transition to retirement assets and how this plays into an estate plan. I teased at the beginning that the SECURE Act, which stands for the Setting Every Community Up for Retirement Enhancement Act, it was passed in 2019, that it really impacted retirement accounts in quite a large way. It started to defer the age at which you have to start taking required minimum distributions from a 401k or an IRA. It used to be at the age of 70 and a half. This delayed it to 72. And actually in 2023, or effective 2023, there was a Secure 2.0 Act that pushed it back even farther. But I'd say one of the more impactful changes through the Secure Act is how beneficiaries are required to distribute IRA assets. So a prior pre-Secure, it was a common financial planning strategy to think about ways to stretch your IRA assets out over as long a period as possible to delay tax payment, to extend the amount of years that you are enjoying tax advantage growth. So prior to Secure, a beneficiary could have stretched their account, which means taking minimum distributions over their entire life horizon, postponing taxation. So that is no longer available. You cannot stretch inherited retirement assets. So what happens today? Well, today you need to fully distribute an IRA within 10 years of the passing of the owner. Now, there are certain exceptions to that rule. One of the exceptions is a spouse. A spouse does not have to distribute within 10 years. But a common occurrence is for, let's say, a parent to name a child as a beneficiary. Used to be that child, let's say they inherit the assets at the age of 50, well, that they could distribute the assets over their lifetime. Now, if you inherit at the age of 50, it needs to be fully distributed within 10 years. So that is kind of changing the game a little bit, because you could be put in a position where a non-spouse beneficiary has to distribute assets, which, if they were made with pre-tax dollars, would come with it a tax bill during the years of your heir's life where they could be in a relatively high tax bracket. Maybe they're in their peak earning years, and you know what? They don't want to realize any more income. So that kind of flips the script a little bit about how you, as the owner of the retirement asset, may choose to spend down your retirement assets and cover your expenses in retirement. So I'm seeing more and more individuals thinking about taking distributions from their IRAs earlier than they otherwise would have. There are other strategies as it relates to retirement distribution strategies. I actually have a book on my desk as we speak. Ed Slott is a widely quoted IRA expert. He had a book that I've referred to over the years, The Retirement Savings Time Bomb. Well, guess what? Post-Secure, he had to rewrite the whole book because it changed for so many different reasons. And you may think about, let's say, when you're in your 60s, starting to take a distribution from your IRA. Or maybe you would think about, when you're still working, not only contributing through a pre-tax 401k or a 403b, but perhaps to save via a Roth. Because remember, if you save through a Roth, yes, you're paying taxes today on that income, but it grows tax exempt. So yes, your heirs would need to distribute it within 10 years, but that distribution is not going to translate into additional taxable income. So there are some rules that are included here about who's considered a non-spouse beneficiary and if they're over or under the 10-year requirement. Again, this is a very nuanced conversation here. I do want to outline that currently by 2033, the minimum required distribution age is going to be the age of 75. So a lot of workers today are not going to have to be forced to distribute assets until that point. Now, the surviving spouse can also then name your own beneficiaries. So oftentimes, and I see a question actually in the chat, is it better to make a spouse as the beneficiary? A very common occurrence is to name your spouse as the primary and your children as the contingents for beneficiary designations. From a will standpoint, to leave it to your heirs, depending on how complex or how large your estate is, there could be reasons to pass it directly to your children. That's considered, or perhaps to even your grandchildren. That's considered a generation skipping transaction. But oftentimes you pass it to your spouse, and then when they pass, then they'll have to make some decisions about further distributions. You may be thinking, oh, I found a loophole. I can name a trust as a beneficiary and avoid the 10-year distribution. No, the IRS figured that out, and trusts are also required to distribute within 10 years. However, I shouldn't say the IRA held by a trust, the IRA needs to be distributed within 10 years, but then those assets can stay underneath the umbrella of the trust. So that tax trigger needs to happen within 10 years. However, if you want to have some control, they say control from the grave is actually the saying, you could put the IRA in a trust, and then you could specify terms through which the beneficiary of that trust can access the assets. So I've went 52 minutes. I know this is a dense topic. I appreciate your attention. I want to recap by outlining these 8 important steps. If you want to throw into the chat any remaining questions that you might have, I'm happy to address that within the hour that we have allotted today. Again, if you have not updated beneficiaries, that's a great takeaway. Think about if you have a will and when the last time it was updated. You want to absolutely make sure you have healthcare directives. And again, this is my public service announcement. Make sure the people you care about have healthcare directives as appropriate. You want to consider that POA, which is short for power of attorney. For some of you, using a revocable life insurance, a revocable trust or an irrevocable life insurance trust could be a consideration. For more complicated scenarios with trust, I would definitely encourage you to engage with legal counsel and legal advisor in that regard. Include your financial advisor just so that everyone's speaking to one another. I'll give you an example. I've heard of scenarios where a family has engaged with an estate planning attorney. They sign their documents, they get everything squared away from a documentation standpoint. But guess what? Part of their estate plan included moving assets into a trust. Well, guess what? The attorney can't do that. So then you've got to coordinate with your advisor to make sure maybe there's additional accounts you need to open, or maybe you need to change the titling of certain things. So that's an important consideration. This is not 100% an estate planning topic, but it informs your estate plan. Thinking about how you're going to distribute retirement assets has estate planning implications, obviously retirement income planning. Thinking about your gifting strategies, if that's important. I'll mention something here. If you're a pre-retiree, as you get closer to the age in which you're going to be required to take a distribution from an IRA or from a 401k, there's something that's relatively new post-secure. It's called a qualified charitable distribution. That's a mouthful. A QCD. Qualified charitable distribution. That allows for you to take up to $100,000 of your required minimum distribution and give it to a charitable organization. And that $100,000 would then not be taxable to you. So that's important. That's something that some people consider, and then thinking about eliminating those estate planning, those estate taxes to the extent appropriate. I'm including here the contact information for myself. Many of you may also know my colleagues, Kevin Mahoney, Stephen Zakarchik, Tom Small. I will be sharing with those that have registered for this program, not only the slides, but an essential documents checklist along with the executor checklist. So I'm just going to take a minute, and yes, absolutely, you can get a copy of the presentation. I will be sharing that. If I don't get it out today, I will get it out Monday, not to worry. I also have a question here, why someone would opt for that's a great question. Why would you go for an irrevocable trust instead of a revocable trust? Well, assets held in an irrevocable trust have the opportunity to be included outside of your estate if it meets certain parameters. So managing the estate tax is something that that you would be that would be a potential benefit to that. Yes, so that would be a reason. Once you start thinking about the opportunity to include trust, and if that makes sense, again, that's really a trigger. That this course here was the introduction, the 101, so to speak, version of estate planning essentials. There's certainly more complicated discussions that I'd be happy to answer questions on a one-on-one basis, but certainly it'd be time to inform and to reach out to legal counsel, any estate planning attorney that you may have. So thank you for your time today on what I can appreciate is a very dense topic on a Friday, but I hope it was a good investment of your time. And, you know, just like with your retirement plan and your financial plan, you want to start with consideration of what are your objectives, what are your goals, and where are you today? You know, the idea of any type of education that we offer to participants in our retirement plans is that we want to meet you where you are today and acknowledge that we're all individuals with unique needs and goals, and help you to support making progress on your personal financial journeys. So with that, thanks so much for joining.